So welcome everybody, and thanks for joining this webinar. For those that don't know me, my name is James Gliddon, a disputes partner at Foot Anstey. By popular demand, I've been joined by others from across the team. We've got Alex Hammond from our commercial team, Stephen Richards and Catherine Haugh from our dispute resolution team too. If you would like information about our employment issues associated with coronavirus, our employment team have previously prepared a webinar that is still available. And I'm conscious that there's still plenty of confusion around furloughing, and it's critically important to ensure proper processes are followed to qualify. There's a lot of information on our website, and again, the previous webinar is also available. Our previous webinar on business-to-business risk, tackling the primary questions that were arising in the previous few weeks on force majeure, frustration, insolvency and fraud, is still available. There is also plenty of material refreshed on our website hub, which we'll refer to a couple of times throughout this session. But if at all you want to connect on LinkedIn, I try to summarize the previous week's publications in one place, so do feel free to connect there. But if you joined our last webinar on business-to-business risk, you may recall that the rather conservative ambition for these sessions is to offer you some practical assistance in the context of the questions and issues that we are frequently coming across, with the hope that you may avoid and limit risks in the mid to longer term when some stability is restored. At the very least, you should feel better informed on the legal issues and the commercial issues, so you can cut to the chase in your conversations with your professional advisors. There is a relatively little we can add to the mountain of macro analysis that's out there at the moment, so we wanted to dive straight into the questions. And we've collated commonly asked questions, and we'll tackle those in the course of the next 50 minutes or so. But one of the common threads that we see running through these questions is a concern around customer confidence and PR. And we highlighted in our previous webinar the large degree of forbearance that is around at the moment, which of course should be welcomed, but of course also preferably documented. That forbearance, however, depends whether it's from business counterparties or consumers, depends on trust. Trust that your business will behave in a fair way in the future. Therefore, in the current climate, when we advise our clients on the options, a really key feature of our advice is they confront these issues with what's the right approach, as getting it wrong can engage a PR risk, which is much more damaging in the long run than an individual transaction or relationship. So to start the content of the webinar, I'd like to introduce you to Catherine Haugh. And when she comes off mute, I'll remind you to submit questions through the chat facility. And if you have any follow-ups or need assistance on anything else, obviously the team is geared up to help wherever they can. And our contact details will be on the very last slide. So over to Catherine.
Thanks, James. And as you can see from this slide, this first question is about a wedding venue hire business and whether it has to offer customers who cancel refunds as a result of the lockdown. Now, we can all know that the impact of the pandemic on the hospitality and service industries has been devastating. But what's the legal position in this sort of situation? Well, ultimately, it all depends on what is in the terms and conditions between the venue and the client. The first thing we suggest you look for is a force majeure clause. And we covered force majeure in some detail in our earlier webinar, but essentially it's a clause which is designed to excuse a party from performing its obligations under the contract on the occurrence of certain specified events outside the party's reasonable control. So common force majeure events include strikes or industrial action, fire, war, national emergencies, riots, that sort of thing. But to cover the current outbreak, the clause would need to refer expressly to the outbreak of a pandemic, epidemic, disease, or something similar. There are also other legal criteria that have to be satisfied. For example, the party seeking to rely on the force majeure clause must demonstrate that performance is legally or physically impossible. So the fact that a contract might have become a lot more difficult, expensive, or uncommercial to perform won't necessarily be enough. Because of these very difficult legal hurdles, the reality, unfortunately, is that force majeure may not be available in many circumstances. If, however, force majeure does apply, the obligations in question are usually suspended for as long as the force majeure event continues. So in this scenario, your business would be entitled to keep any deposit paid, and ongoing obligations would effectively be paused. This, of course, would be very helpful from a cash flow perspective, where the imperative is to keep the cash in the business, where there are suppliers to pay, and potentially ongoing costs and overheads. Now, what if you don't have the benefit of force majeure clause? Well, then you might instead be able to rely on the doctrine of frustration. And this doctrine allows a contract to be discharged if something unforeseeable, which is not the fault of any party to the contract, occurs after contract formation and which renders the contract physically or commercially impossible to fulfill, or transforms the obligation under the contract into something radically different. There's a good argument it will apply in circumstances like the one we're looking at, where there's been a change in law requiring venues to close, weddings to be cancelled, and large gatherings of people forbidden. Assuming that is the case, the contract will automatically come to an end, and the parties will no longer be bound to perform their contractual obligations, so they'll avoid any liability for breach. Money that's been paid before the frustrating events, such as a deposit in this sort of situation, can be recovered by the paying party, subject to the deduction of the other party's expenses and potentially also overheads, and those deductions could be assessed and awarded by the court. Of course, the difficulty for the events industry is identifying how the law applies in respect of customers who have made bookings for some time in the future, which are probably unlikely to go ahead but haven't yet been technically frustrated. And unfortunately, there's no black and white legal answer to this, but we have come up with a suggested approach which we think is sensible. And that approach is to categorise contracts or customers into broad groupings depending on when the event is due to take place. So the first category might be the customers we've already discussed, i.e. those who have booked an event due to take place in the next few weeks that can't now take place because of the change in law, i.e. the contract has in fact been frustrated. In this situation, as I mentioned, the law says you should refund any deposit paid, less expenses. The second category could be customers who've booked an event due to take place perhaps over the summer. So technically, we can't say right now that the contract has been frustrated because we don't know what the position will be in a couple of months down the line. So the status of the contract and the parties' rights and obligations just aren't clear at present. In those circumstances, we think that the best approach is to have a frank and honest dialogue about the options with your customer as early as possible. A good outcome might then be persuading your customer not to cancel and instead to reschedule the event until later in the year or even next year, meaning that you are able to hold on to the deposit, which of course will be crucial from a cash flow perspective. The final category is those customers who have booked events which are scheduled for later in the year, so let's say September or October onwards. Whilst there may not be any restrictions in place by then which would frustrate the contract, the customers may want to cancel anyway because they've got cold feet. In those circumstances, we suggest you take a fairly robust approach with them, maintaining the position that you're entitled to retain any deposit paid in those circumstances in the event that those customers do cancel. The key factor from a PR perspective is that you should treat all your customers in each category the same. This minimises the risk that word will get out that you're offering refunds to some customers but not to others, which could of course be damaging reputationally. If you can justify objectively how you're dealing with each category of customer and you treat all customers in that category consistently, you're more likely to be able to weather the storm, maintain the broad support of your customer base, and crucially retain as much cash as possible within the business. I'm going to pass over to Stephen now, who's going to look at these concepts of force majeure and frustration in the context of sponsorship. Thank you.
Thank you, Catherine, and good afternoon, everyone. So this next question is a common one. Certainly for us, we're seeing a lot of this at the moment, and it deals with a situation where you as a client or a business, you are sponsoring an event or even a team throughout a season, and the event or even the season in full or in part is now not going ahead. The club or organizer of the event in question will obviously desperately need the cash in these times, but you as a business will be saying, well, what am I paying for if there are no opportunities to, say, advertise or raise profile through the sponsorship? So that's what we're going to look at. Now, the sponsorship deals that we're seeing at the moment, it's not universal list, but the ones we're seeing are normally on the sport clubs or the organisation's standard terms, which means they're more likely to be favourable to the entity being sponsored than to the sponsor itself. But obviously it all depends on it, and we have to look at this on a case-by-case basis. And in looking at your options, one of the first questions to ask is whether the event or the match, say, has been cancelled or simply delayed or postponed. Now, if it's a one-off event and the event is cancelled, then your options under the contract will have likely been set out and crystallised by that stage. If, though, which is more likely, you're a long-term sponsor, or there's a delay or a postponement as opposed to a cancellation of an event, then it might be said that you'll still obtain full value from the event at some point, and that there's been no contractual breach on behalf of the club or organisation as things stand. You also have to remember that in circumstances of delay or ongoing sponsorship, there's also the ongoing relationship and the value of that relationship to consider, which is often paramount, and I'll come back to that. As Catherine's mentioned, with these situations, it's a typical lawyer thing to say, but as always, you need to start with the contract, and where force majeure provisions do apply, it's important to bear in mind that they don't necessarily apply equally to both sides. And what I mean by that is normally it's the party which has something to do, to perform, in other words, that is relieved of its obligations. So in sponsorship terms, this may be the obligation on the host or the venue to play the matches or to hold events attracting the crowds or media. Conversely, where those events are not held because of the current pandemic, there is a real risk that the sponsor will still have an obligation to pay. And that's because COVID-19 hasn't actually prevented you as the sponsor from paying. The bank still works and you can still pay. So in some respects, the obligation still stands, and you can't use force majeure provisions if you have one, normally to your advantage. In the end, it depends on what your contract says, and we have seen some more balanced contracts that do contain provisions which allow payment suspensions in certain circumstances. If you don't pay sponsorship that is due, either because of your own cash flow problems or you don't think you get any benefit, well, and there is a risk that in doing so, the sports club or the organisation on the other side of the fence can terminate through the contractual provisions or allege that you've repudiated the contract and gives them the right in any event to bring it to an end. Look, in either case, if no alternative sponsor can be found, you might be on the hook for claims, not just for unpaid sponsorship sums, but also any future sponsorship if the club or organisation in question can't find an alternative. Now, if it becomes truly impossible to fulfil the contract and you don't have a force majeure provision which decides how to allocate risk in these circumstances, you may be able to show that the contract has come to an end through frustration, and you've got no obligation, therefore, to pay any future sums. Indeed, possibly not a requirement to get some money back you've already paid. However, as Catherine's already mentioned, satisfying the test for frustration can be quite difficult. And of course, and this doesn't apply in any event if you do have a force majeure provision in your contract, which by and large most contracts seem to have these days. It's worth mentioning that we have seen other possible useful clauses in sponsorship agreements, such as rights to renegotiate if, say, the league or the structure of the event changes. That may be applicable here. So if these clauses do exist, that might allow you as a sponsor to exert more pressure for a delay or a pause in payments. Now, that's the contract, and it may be that the force majeure or similar provisions fairly apportion the risk in these circumstances between the parties. However, it's not our advice, though, that you should always jump in with the other side in terms of negotiations, straight in with the legal position. Of course, it's right to get some legal analysis done if there's any uncertainty around this. But by and large, a frank discussion with the sponsor, often held on a without prejudice basis, is far more likely to lead to a result that is acceptable to both sides. Because, look, we've seen instances where the contracts are totally favourable to the sports club, for example, but they've nonetheless agreed to a full deferment of payments until we know more about how the sport will resume. And that's even in circumstances where strictly, legally and contractually, they didn't have an obligation to do so. Now, this was achieved really through an offer to discuss the matter really on a common sense basis. And in that regard, it's worth pointing out the logic of this. Look, if there's no sport or event happening, then there's no benefit to the sponsor. And most clubs and organisations will understand that rationale and will not want to alienate their sponsors. And why is that? Well, look, sponsors are providers of cash to sports clubs and events. And at present, cash is king. It's the main concern for most businesses. So even if payment is deferred or reduced, that is better than having no option as a club, for example, but trying to start legal proceedings to enforce your sponsor to pay. No one wants to do that at the moment, even more so than usual. And no one wants to burn bridges with sponsors who are likely to be hugely valuable to the club when the sport restarts. So in short, typical lawyer answer again, it'll obviously depend on what the contract says. But your legal options, whilst they may be helpful, and if so, we can advise you on them, they're not an answer to everything, and particularly where your only obligation is payments. Broader than that, commercial discussions based on a firm understanding, of course, of the strengths and weaknesses of your position is frequently, if not always, the best option. So that's hopefully an answer to that one. Now over to Alex, who's going to consider managing annual memberships during the lockdown period.
Thank you, Stephen. So turning now to look at annual memberships, I think for those organisations who've already collected membership fees, the challenge here is retaining those funds for business continuity purposes during these challenging times. And where organisations are perhaps coming up to renewal time for annual memberships or the start of new memberships, particularly in the sports sector, the focus will be on eliciting payment from customers for the upcoming season or year without any immediate or obvious benefits. So taking existing memberships first, it may be possible to extend these into the following sort of period or year that the membership runs for. But this will depend entirely on the sector which each organisation is operating in and what the membership itself covers. To take an example, as the household name of the National Trust, many people will have an annual pass which gives them access to their venues which aren't currently accessible due to the lockdown restrictions. And I expect the National Trust will be having this kind of conversation around what do we offer existing members who aren't currently in a position to be able to visit their sites. I think the exact length of the extension is going to vary, and ultimately it is completely at the discretion of each individual organisation. But in terms of what to consider, I think there are a couple of aspects. The first is, make sure you're not creating unnecessary negative PR. Customers may feel that they haven't had value for money from any proposed extension. So it's always worth bearing that in mind in terms of how you think your membership base are going to react. And I think the second thing is to think about what the overall period of lockdown is going to be. Ultimately, at the moment, we don't know that. But once it becomes a little bit clearer, perhaps the actual period of lockdown, which is equivalent to the amount of time that most of the venues and events and activities where they're not able to take place at the moment due to lockdown, that period might be the suitable length of extension that you offer to your membership base. It's also worth considering what else you have available to offer members so that they feel they're still getting value for the fee that they've paid for their existing membership year. This could include access to digital material, archive content, interviews or other coverage of key individuals either within or connected to your organisation, anything really that you think genuinely would offer value to those members that you've got currently unable to exercise their full benefits. And individually, I think just consider what other offers or benefits you can share with your membership to make them feel a little bit special. Turning now to look at renewals and new membership arrangements. This is a much more challenging area as people want to understand why they're being asked to pay a membership fee at this stage when there's no change to the lockdown restrictions in the foreseeable future, which restricts the current arts, leisure and sporting activities which so many people are members of. And they may also have financial challenges themselves. Individually, they could be facing a change in their own working pattern, additional childcare, family commitments,
and other factors which could influence their spending priorities, and membership may no longer be sort of towards the top of that list. Your most loyal members may well renew without challenging any of this, but others may resist it. And what we're trying to do here is just help you consider what some of the options are so that you can maintain as much revenue as possible from memberships in the coming months. We recommend communication early with all potential renewals and existing members or potential new members for upcoming membership periods. And giving them as much detail as possible when you reach out to them, things like proposed fees, what the benefits are, any pre-planned special offers or events which are open to members only, to the extent that you can plan for those whilst you remain in lockdown. Ultimately, preparation is going to be key. And do remember that lockdown won't last forever. So if you can begin to put in place some arrangements and benefits for the next membership period, once the government restrictions are lifted, the better position you're likely to be, which will entice existing members to renew their membership and also invite other individuals to become members of your organisation. I'm now going to pass over to James, who's going to talk about paying suppliers and relying on insurance if events are cancelled.
Thanks, Alex. So yes, insurance has been a hot topic, and questions have been coming in from venue operators and events organisers. It sounds very basic, but the first thing is to pore over the terms of your policy and any schedule or any endorsements to your policy in great detail, and fundamentally approach your insurer early. You can't invalidate your claims by early notification, but you certainly could risk them by late ones. The policy terms you'll need to be thinking about and looking at closely are firstly business interruption, which is typically a section within a commercial combined policy. Looking at communicable, infectious or notifiable diseases within the policy. Focusing on event cancellation provisions, but also and critically the general exclusions and limitations on coverage, which are typically for specified diseases. To give you some of the context as to some of the things we're to think about based on the approaches we're hearing being taken. Firstly, generally business interruption, which was first highlighted when pubs were asked and not told to close. The general concept with business interruption, it typically requires some physical damage to a property, whether it be a fire or a flood, for instance. Secondly, communicable diseases or infectious diseases cover is an extension to a primary policy, which typically covers an identified and named disease. Exclusions from that coverage which again stems from the current coronavirus crisis, should be thought about in terms of whether there are specified named disease, and bear in mind that COVID coronavirus is a strain or a strand of SARS, so that broader policy exclusion might come into play. Also, depending on the renewal dates, some insurers we hear are taking the stance that coronavirus was a known issue at the time the policy was incepted. Bear in mind that the first widely reported cases started in November and December last year. Other key dates to bear in mind are the 5th of March, when it was classified as a notifiable disease, and the 11th of March, when it was formally declared a pandemic by the WHO. And obviously that will link into when some policies were renewed. And obviously, an obvious point is in terms of the amount of coverage will be defined in line with the policy terms. But a word of warning and caution from experience, don't be surprised if your initial response from the insurer's claims handler is negative. That is not necessarily the end of the story. It might take some time and some advice about coverage or potential coverage under any event cancellation policy. And so it might be appropriate to challenge insurers where appropriate, and there is some merit to do so. In the event that the insurer pushes back, we suggest you take some time and advice before doing anything else. Certainly the validity of an argument that coronavirus was known when the policy was incepted is not clear, and there are risks around this. Initial stances by insurers are often successfully challenged, and particularly bear in mind the comments we've made earlier about PR and reputation, insurers may not particularly want to get a reputation for bouncing cover or refusing coverage in particular circumstances. But what about the suppliers? In the meantime, your primary liability vis-a-vis suppliers has not changed. We'd recommend you engage with them early and consider some of the issues we discussed in the last webinar, and Catherine and Stephen have already covered, around force majeure, frustration, particularly forbearance. And I mention those points as there is a real risk that any settlement of a supplier liability, which then you seek to make part of your insurance claim, may be rejected, particularly if you had a reasonable basis to avoid that liability. Generally, admitting liability and settling potential claims or making payments should always be sanctioned by insurers. And therefore, you may wish to engage with suppliers in doing the right thing up front, but it is always preferable to reserve your rights. And we talked about reserving rights and making communications subject to that reservation and subject to contract in our previous webinar. Is at least do this whilst you bottom out the position with the insurers. And if you need to use your broker to expedite things, that's absolutely fair. And mentioning brokers, I suppose it's one, if you're reaching a conclusion that you're not covered, but where you expected to be covered, it may be worth revisiting the pre-contractual discussions and expectations. It's not always viable or a live prospect, but it is certainly something worth bearing in mind to consider whether the policy itself was properly suitable for you at the outset. So that's a short one on insurance, and I'm going to pass back to Catherine now. She's going to talk a little bit about furloughing of staff and meeting existing contracts.
Thanks, James. Some great tips there about dealing with insurers. So this next question that I'm looking at focuses on some of the logistical issues arising from furloughing employees and how that impacts on contract delivery. And there are two aspects, I think, to consider here. The first is whether you can manage your furloughed employees in such a way as to mitigate this risk altogether. And secondly, what you can do if you can't meet your contractual commitments regardless. In relation to this first point, well, this isn't obviously an employment-focused webinar, so I don't want to get into the detail of furloughing, but it is, of course, a substantial risk that a large proportion of the workforce may become unwell during this pandemic, and the planning for this scenario is therefore key. If you do have a large number of furloughed employees, you can lift this status and bring employees back to work after they have been furloughed for a minimum period of 3 weeks. A furloughed employee that is brought back to work to fill any gaps can be put back on furlough leave as and when needed. However, they'll then need to remain furloughed for a further 3 weeks before they can work again. So bearing all that in mind, how do you plan ahead for the risk of employees becoming unwell and unable to work? Well, the practical starting point is that we suggest you look at your existing contractual obligations and work out the type and number of employees you will need to fulfill those contracts and the timescales involved. The aim here should be on undertaking an early and very analytical focus on the most profitable and important contracts and the ones that need a minimum service level or number of people to service them. As once you know what those contracts are, you can plan your employee resource properly around that. Now, moving on to the second point. What if your business does become stuck and you simply don't have enough resource available to fulfill your contractual obligations? Well, the key risk here obviously is that you're going to be at risk of breaching the terms of a contract, and this could give rise to liability for damages and potentially also termination of the contract. If that's the case, it's imperative that you understand your legal position, as this will inform what you do next. So it's important, for example, to understand what a breach of contract claim actually looks like. It might not just be the contract price that you're on the hook for, but also potentially also significant damages for loss of profit or that sort of thing. Where your business is at risk of liability, you also need to identify whether it's possible to rely on any force majeure clause in the contract, as I already mentioned, and if not, to consider other legal remedies such as frustration or change in law provisions. Once you know what the parties' respective rights and obligations are, what the risk to your business is, and therefore how much bargaining power you have, we recommend that you then speak to the other party to the contract sooner rather than later to see if there is any flexibility in the timescales for delivery, or if your obligations under the contract can be relaxed temporarily or even renegotiated altogether. Addressing this head-on could help avoid the risk of finding yourself in breach, as I mentioned earlier. The best approach in these circumstances is to have a conversation with your counterparty about how the situation may be resolved to both parties' mutual benefit, and if necessary, this can be on a without prejudice basis so that both parties can be comfortable and open and frank in their approach. Regardless of the strict contractual position, there really are no winners in this sort of situation, so hopefully your counterparty will be amenable to reaching a compromise. Ultimately, I think the key message is not to bury your head in the sand, as this could lead to an unwanted and costly dispute later down the line. By far, our experience is that the best approach in these unprecedented circumstances is to get to grips early with the merits of your legal position, and then, armed with that knowledge, engage again early with your counterparty about the problem, as I said, on a without prejudice basis if necessary. So to sum all that up, our suggestion would be that you start by making sure you're managing your furloughed workforce in such a way that you can fill any staffing shortages due to illness. You take extra care to plan ahead for your contracts during this time to make sure that you have the requisite staffing levels in place. If you find yourself in a bind, get to grips with the extent of the risk, take early advice on the legal position, and in particular identify whether you have any of these remedies through force majeure or frustration available to allow you to avoid liability for breach. And then the final point is just to emphasise the benefit of having this early open dialogue with your counterparty to see if any potential issues can be negotiated and resolved amicably. I'm going to pass back to Stephen now, who's going to look again at this issue about refunds, this time in the context of ticket sales. Thank you.
Thank you again, Catherine. So we here are getting a lot of queries from businesses, particularly, for example, charitable organisations, but businesses in the arts and leisure sector who, in the current crisis, have had to close the venue, hopefully temporarily. They're suffering a drop in revenue and are getting demands from customers for repayments. So the question arises is how best can they deal with those demands, whilst at the same time trying to meet their own needs for ongoing revenue, but also trying to keep their customer base happy. A very difficult balance, but one I think most businesses with the right support can find their way through. Obviously, this set of circumstances is hugely disappointing, amongst other things, in an uncertain position, which so many venues find themselves in at present, particularly as there's no indication of when the government's advice and restrictions on closure will change. The impact this measure has had on organisations' cash flow is likely to be distressing, to say the least. And careful steps will obviously need to be taken to manage all financial commitments during this time. We're keen to support as many businesses as possible who find themselves in this unfortunate situation, really by offering up the best as we can some practical and commercial advice on how to balance these competing interests, and most importantly, to maintain good and long-term relationships with its customers, which is critical for the long-term viability of these venues. So, in terms of managing customers' expectations, there are some straightforward actions you can take which will hopefully address their questions and concerns, and also ensure they return to the venue once the lockdown restrictions are lifted. Some of these steps will protect revenue from tickets already purchased, and others will focus on maintaining your brand and reputation from a customer engagement perspective. So just by way of an example, so for customers who've already purchased a ticket for an upcoming event or a visit to your venue, we recommend considering one or more of the following potential options, which we've all considered here with one or more of our clients. So the first is to offer to honour the ticket, but in due course, in effect, to postpone the ticket once the lockdown is lifted. This is particularly advisable where you've got customers who've paid for, let's say, a general admission ticket to your venue rather than for a specific event. You may want to give a long stop date by which such tickets must be used, although, of course, at the moment this is difficult without knowing when the current restrictions will be lifted. But in those circumstances, if you're open and transparent about this and you're decisive about it, a point I'll come back to a bit later, I think most customers will see value in that and won't necessarily be demanding their money back, even though that's strictly what they may be entitled to under the terms and conditions. So first and foremost, see if you can postpone the event and give someone an admission at a later date. That sounds obvious, but it's worthwhile remembering these some basic points. Secondly, possibly ask for you as the venue to retain the cost of the ticket in return, for example, for making available digital content of your venue, e.g. a virtual tour, or coverage of a previous similar event to customers. For charitable organisations, for example, you may wish to emphasise here that ticket bookings are a source of revenue, and to ask the customers to consider donating the cost of their ticket to help fund the organisation's operation at this challenging time. And again, although everyone's got cash flow issues at the moment, I think we've been surprised and continue to be surprised by customers' willingness to help the venues that they support, as long as those venues are being upfront and transparent about them as to what their needs are. Generally, by and large, the customers that I think are difficult and won't cooperate, they tend to be few and far between. So it's always good to try and come up with different options for customers. There will, of course, be lots of individuals who quite rightly will ask for a full refund back. Ordinarily, under most people's terms and conditions, if an particular event is cancelled, and it's through no fault of the customer, the paying customer, then they're entitled to a refund. Again, check the terms and conditions that apply. But with all cases, it's best to deal with requests for refunds on a case-by-case basis, see whether or not there's any blanket or specific individual requirements or willingness to take up some of the other options we've talked about. But of course, always act calmly and professionally to satisfy the customer, despite this being an uncomfortable position for you to be in. At the very least, it can take time to make refunds, and I think it's always important to explain to customers that process may in fact take slightly longer at present, but I think any information that you can provide will help to pacify disgruntled customers. So at least a couple of these options will ensure that you can maintain existing revenue from tickets already sold prior to the lockdown being enforced, which will hopefully help to ease some of the financial pressure you're experiencing across your organisation. Do of course also consider some of the government's financial support packages, such as the obvious furloughing employee schemes and the business loan schemes. These are topics of themselves and outside the scope of this webinar, but do visit our website for further details if those schemes are of interest to you. Now, despite this being a stressful time for businesses due to financial pressure, it's crucial, amongst all things, that you maintain a stable and transparent approach to customer interaction and engagement. A helpfully worded email communication or statements on your website are likely to go a long way and to land well with your customer audience, which will ultimately result in increased customer loyalty long term. And here, with anything, communication is key. I've seen this both in terms of advising businesses, but also by being a customer on the other end. Be proactive about what steps you're going to be taking. Don't really wait for customers to be making requests. Importantly, be decisive about what you're doing. In a lot of these circumstances, there's no strictly right or wrong answer, certainly under the contracts. There's a lot of ambiguity because the type of events we're looking at now just haven't been encountered or thought about. So be decisive. And then communicate it and be transparent. As Catherine said, make sure you're fair to customers or groups of customers and treat them equally. But just be open in how you propose to deal with the situation, and you'll be surprised that most customers will respond positively. So, and finally, just keep an eye on what other organisations in your sector are doing. Of course, each organisation will have its own customer base, its own terms and conditions, but maintaining a similar approach on a sector basis, as far as feasible, I think will stand people in good stead. It's important to bear in mind here, for good or bad, the power of social media on your brand and reputation. You know, that is a webinar again in its own right, but with all of these things, being seen to do the right thing, not being you know, standing out from the crowd in terms of doing the wrong thing, and in parallel with that, being seen to be fair, to be consistent, to be reasonable, and to be open and decisive, is likely to keep you on the right path, both financially and reputationally. So that hopefully gives you a short summary oversight into that question. Now over to James again, who's going to consider alternative approaches to debt recovery.
Thanks, Stephen. So, yes, I mean, focus is on cash quite clearly in a lot of businesses at the moment, and this question is really centered on, well, I might otherwise have pursued a debt recovery process, but given the current situation, is that the right way to go? Is there anything alternative that I can do, essentially to see cash come back into the business? Well, absolutely, and we're seeing decisions entirely outside of business norms being taken every day with the focus on cash at the forefront of people's minds. For instance, tenants are dictating to landlords that they won't pay the next quarter's rent, or changing to a monthly basis, which is pretty unheard of, and prior to the current situation. And we're seeing creditors simply telling companies they won't be paying invoices on time. Of course, there are some orthodox approaches you can take in relation to debt collection, but these generally depend on whether the debt is disputed or not. We've previously discussed the reality of this in the last webinar and how long that may actually take. And as such, creditors are now focusing on their credit control and ramping up their approach on credit control, whilst the push factor on the other way is debtors are trying to push out their payment terms. It's not surprising that law firms particularly are looking to their commercial litigators to pick up where their transactional lawyers might have slowed. However, the current legal context and expectations are different. There is a much more there is a expectation that, given the circumstances of the current crisis, this is not the financial crisis that we saw 10+ years ago. It is something much more impactful on each of us, that those commercial orthodoxies are not necessarily followed here. And particularly given that there is a number of sort of legislative changes and directions coming from government about what some of those options and levers you would normally pull, whether they are still available and whether they're being taken away from you. So in the property litigation context, non-payment of rent would typically include a remedy of forfeiture, but that is being taken away by government. Similarly, banks are being mandated by the FCA to give debtors payment holidays and not to enforce. So whilst there's been no legislation or direction yet for general commercial debts, it's prudent to assume that something is going to be coming. The Chancellor has indicated reforms, including a new company moratorium, which would prevent the enforcement of debts for a period whilst the debtor takes advice and considers its options. And there are some indications that this will be coming out over Easter or just after the Easter break. So whilst some cliches still hold true, namely those who shout loudest often get paid first, but also conversely you can't get blood out of a stone, it's important to think about the practicalities, such as the speed of collection and the other party's access to liquidity. For instance, do you know that they have access to the various government schemes? Because these are intended to keep the wheels of business turning. We've heard from the Institute of Chartered Accountants that it is expected that the release of that liquidity in those funds is to ensure small businesses particularly, but also up to the mid-size, continue to get paid. So when we're all looking at mechanisms to keep cash in the business, we've seen a combination of carrot and stick or forbearance and incentivization work really quite successfully. For instance, creditors can try to share risk with their debtors. For example, if you can't pay on time, rather than rush into a formal enforcement process where the cost is borne initially by the creditor but is subsequently passed on to the debtor, the creditor could agree an interest inclusive sum and a mechanism by which the debtor can pay, which allows for credit checking at various intervals. Part of that model envisages some payment now, but the point is to get the cash flowing faster by sharing the risk rather than that old-fashioned, that binary approach where the debtor keeps all of the money until they're actually forced to release it much later and at a higher sum than they otherwise would. Other factors that can be built into some of these compromise models are wait longer, you pay more, there is an early settlement discount, there are acceleration provisions if instalments aren't met, there is a clear acceptance of liability so that if you do need to resort to litigation or an insolvency process, that would be undefended and therefore not rack up as much cost. Or ultimately the provision of further security or some security to lower the creditor's risk. And this is where your finance director or finance department might welcome some support to evaluate the options across a wide debtor book to consider which would be the best levers to drive the best results, because you can quite clearly understand that it's not a one-size-fits-all. And you could build this into a tapestry across a portfolio to ensure where there is available cash, it's brought in as quickly as possible, but maintain some flexibility within the business, in line with the business's needs. And so to re-emphasize that point, why would you take this unorthodox approach? The answer is simple. You just look at the practicalities. If you issue court proceedings today or a winding up petition on an undisputed debt, it will be several months before you make progress. Now, it doesn't mean you shouldn't have it as a fallback option or to encourage the proper engagement in any compromise proposals, but it should never be the first or the only approach. And like we've said time and time again here, given the current context, a more commercial, human approach to conversations with your debtors or your creditors can only drive benefits when considering the overall objective of getting cash into the business. If you'd like to think about how that model might work a little bit more, I'm conscious that my partner Pete Singfield and colleague Brett Eels have published a note on this today. It's gone live on our website, so please do take a look. And frankly, any of us would be very happy to help formulate strategies in terms of debt portfolios. Just as an addendum before I pass on to Alex for the final question, the extent businesses are suffering cash flow pressures and competing priorities means that it's imperative for directors to be aware of their duties when making significant decisions and deciding who to pay and who not to pay. So whilst you'll have seen that wrongful trading provisions are being relaxed, that doesn't relieve directors of their overarching duties or protect them against actions brought by disgruntled creditors. Taking advice early can often give businesses, and particularly those people in key positions, confidence to take decisive action. The decisive action they need to at the pace that's really necessary given the current context. So I'm going to pass over to Alex now for the final question. So over to you, Alex.
Thanks, James. And This particular question that we're looking at covers a UK-based holiday lettings company, but more broadly, really, it's just about relationship management. So I hope that you can, although there's a specific context here, I hope that you can think about applying perhaps some of these principles to your particular situations where you're working in a slightly different sector. So looking at this holiday lettings company scenario, for them, they are considering their property owners' interests, their guests and their booking system, and their supplier network, who ultimately support them with running the efficient changeover and maintenance services that go hand in hand with running a successful business in this particular sector. And the questions really are how do you balance all of these different relationships? Who do you prioritize? And how best do the company themselves as an agent for the property owners seeking bookings ultimately protect their own financial position, particularly in light of lockdown, where there's non-essential travel forbidden and there are cancellations here, there and everywhere. And it's really a chicken and egg situation, because ultimately to get the business through the lockdown period, it's just trying to keep everybody happy in the best way possible. Looking at guest bookings first, I think that, well, inevitably these can't go ahead in the current lockdown period, and guests will need to either cancel or postpone their booking in order to comply with the lockdown guidance. And I think that hotels and holiday lettings companies are in the same boat insofar as they can't be seen to be accepting bookings and flouting those lockdown restrictions. And it does create a bit of frustration situation, and we touched on that earlier in the webinar around how best to try and resolve that, where actually neither party can honour their contractual obligations. But also, I think, just from a really practical perspective, ultimately, and again, these are some of the themes that have come up earlier in the webinar, transparency and clear communication and proactivity can really set you ahead of other businesses. And I think in this particular scenario, reaching out to guests who have got bookings, particularly in the immediate future, to say, look, we're sorry that we're not able to welcome you at this time, and try and suggest a postponement rather than a cancellation, because ultimately that will mean you can keep the payments that you've received to date in the business rather than having to deal with the administrative task of refunding them. And equally, it secures future revenue, both for the company and also for the property owners in terms of the rental income that they'll get. So I think just a really practical approach to communicating, again, as early as you can, but without knowing how long lockdown is going to last. We appreciate that it's quite hard to second guess too far ahead into the future. And of course, the exact remedies will depend on what the T's and C's say. And we're trying to keep this as practical as possible. But as I think Stephen said earlier, we're lawyers, and ultimately the contracts do end up sometimes saying more specifically what we have to do here. But I think there is an element, as we've all touched on in these questions, of actually everyone understands the current difficult position that everybody is in. And there is an element really broad of sort of understanding and flexibility. And I think it's really important to maintain that. I think looking at property owners, the lockdown restrictions are obviously going to have an impact on any revenue that they're getting. And they may be reluctant to have to cancel bookings and give refunds. So I think, again, a really clear communication strategy here is key. Postponing bookings obviously will secure that future revenue, albeit at a later date for them. And ultimately, you might want to recommend that they take a mortgage holiday if they are concerned that the drop in income is going to mean that they can't meet their own financial commitments. There may be other options that they can explore individually to try and ease the financial pressure if they're not getting the rental income that they were expecting. Again, ultimately, it comes down to some good relationship management, because at the end of the day, once lockdown is finished, there will be a position where owners are going to be welcoming bookings, guests are going to want to travel, and ultimately that's the best position that a company in this particular sector can be in, and trying to maintain those relationships on each side through this difficult period is going to be key to that. And the third area is supplier relationship management, because ultimately being able to deliver the quality of service that you're offering to guests, but also to property owners, maintaining your supplier relationships is going to be key so that you can continue to offer the high quality of experience and service that you say you will in terms of your website and your marketing material. And looking at suppliers, as we've talked about earlier, some companies may find themselves trying to operate on skeleton staff due to either illness or furlough, which means that they might not be able to perform their contracts to their usual standards. And Catherine's earlier comments may be useful here to consider how to manage and prioritise existing contractual relationships with suppliers. I mean, it may be really practically, there are fewer bookings and therefore the demand is lower for services to take place, and therefore your supplier network is already operating at a slower pace. But again, coming back to areas of things like payments and either delaying or deferring payments for them for the services they have already delivered, and then ultimately maintaining a good working relationship with them so that they are there for you when the business picks back up again is going to be key. And again, the final theme I think that we've all really drawn out here is trying to maintain an element of consistency across all your different relationships that you're juggling during this difficult time. Consider how you're using your publicity, your website, and your other sort of social media and communication channels, and really use those to be as transparent and open as you can be, but also maintain an element of flexibility because there are still a number of unknowns. How long is lockdown going to last? How are we then going to become back to some sort of normal existence? And businesses aren't expected to have all of those answers. And equally, customers do understand that's the case. And as long as you can continue to maintain that transparent but flexible approach, coming up with some really practical solutions as what we've talked about through some of these examples that we've discussed today will hopefully help you navigate your way through. So that brings us to the end of our questions. And I'm going to pass back to James now, who will share some concluding thoughts.
Thanks, Alex. Yes, so that's the end of those questions. Plenty arising every day, every week. Hopefully those questions may be helpful and resonate with you, even just to get a sense of what businesses like yours are facing across the market. We're all facing the same sort of decisions and issues about cash flow, productivity, etc., but also whilst facing the real, very personal threats to health and well-being, whether in our businesses or at home. And we've mentioned PR a few times, and some of the decisions we're facing are not straightforward. We've seen broadly in the press many examples where businesses have not got it right, and we can be sure that they weren't aiming for the PR fallout they have suffered, but they do act as warnings. For some where public opinion is critical, such fallout in the long run might be terminal. Having acted for banks after the 2008 crash, and also in a profession which doesn't necessarily garner much public sympathy, we certainly understand you can't please everybody. You can avoid some own goals, and where you may be able to engage PR firms, great, but many can't. But it might sound trite, but in testing times it does help to check your instincts as what is right, and you've obviously got your own tests, sense checks for those sorts of things, whether it's that Daily Mail front page story or what, to judge how your decisions might be seen. I'm yet to settle on what the right approach to an anonymous Twitter user is, but there's also a case of when not to engage, which is really important. And of course, if you're still not sure, get a second opinion. There are no stupid questions right now, and as I said, the whole team is geared up, happy to help. We're very keen to jump on calls or a video con at very short notice just to offer some perspective or a sounding board. And whilst taken individually, whilst these are unprecedented times, taken individually, these issues are familiar to a lot of us, and the approach should be maintained it should be consistent, and the approach should be the same. So wish you all the best. Thank you for joining us. Keep a lookout on our hub and our LinkedIn feeds for updated content when new developments come out. And if there are subsequent questions you want to fire our way, then please do feel free. But thanks again, and all the best.
Foot Anstey, powering your ambition.